There is a family in California right now paying a probate attorney to transfer a house their father specifically tried to keep out of probate. He had a trust. He paid an attorney to draft it. He signed it, filed it, told his kids the house was protected. What he did not know, and what nobody told him, was that signing the trust document and actually moving the house into the trust are two completely separate steps. He did the first one. He never did the second. When he died, the deed still had his personal name on it. The trust existed on paper and nowhere else. The house went to probate court anyway, exactly like he had no plan at all. His family is now 11 months into a process he spent $2,000 specifically trying to avoid. That is not an unusual story. It is one of 4 deed mistakes that send homes to the state, to probate court, to creditors, or to the wrong people entirely, while the owners believed the whole time that everything was handled. The mistakes are different. The outcome is the same. The house does not go where you intended, and by the time anyone figures that out, you are not there to fix it. Today I am going to show you all 4. Every single one is fixable before it becomes permanent. This video is for educational purposes only and is not legal, tax, or financial advice. Consult a qualified estate planning attorney before making any changes to your property. My name is Daniel Kim. Every week I break down the financial rules, the legal traps, and the strategies that protect retirees from the things nobody else is explaining clearly. Hit subscribe and turn on notifications so you never miss a video. Let's go. Mistake number 1. The deed that is still in your name. This is the one that starts the entire chain of damage, and it applies to more retirees than any other mistake on this list because it requires nothing to go wrong. You simply have to do nothing, and the state steps in. When you die with your home titled in your personal name and only a will to transfer it, your home goes directly into probate court. There is no exception for how clearly you wrote the will, how long you have owned the house, or how obvious your intentions are. The will is a set of instructions. Probate is the court process required to execute those instructions. One does not replace the other. Here is what that process actually looks like for your family. Your children hire a probate attorney. The estate is filed with the court. Creditors are notified by public notice. Anyone who has a claim against your estate or who wants to contest the will now has legal standing to do so. The court reviews the estate. Hearings are scheduled. Eventually, months to years later, a judge approves the transfer. Average probate takes 16 months from filing to close, according to estate settlement data. In states like California, where attorney fees are set by statute as a percentage of the gross estate value, not the equity, the fees on a $600,000 home run roughly $15,000 to $40,000, regardless of how simple the estate is. That money comes directly out of what your children inherit. And while all of this is happening, your family is paying property taxes, insurance, and maintenance on a house the court has not released yet. They cannot sell it. They cannot refinance it. They are maintaining an asset they do not legally own yet for a process that takes the better part of 2 years. Every dollar spent on probate and every month spent waiting is a direct consequence of how the deed was titled, not the will, not the trust, the deed. The fix is straightforward. A revocable living trust, properly funded, takes your home out of the probate equation completely. Alternatively, in 33 states and the District of Columbia, a transfer on death deed accomplishes the same result at a fraction of the cost. The house transfers to your named beneficiaries automatically upon your death, with no court involvement, no attorney fees eating into the estate, and no public record of what you owned. The transfer on death deed is not available in every state. New York does not recognize it. Some states have specific execution requirements, but where it is available, it is one of the most efficient probate avoidance tools in estate planning, and most homeowners have never heard it mentioned. If you do not know how your deed is currently titled, Pull your property tax statement or contact your county recorder's office. The answer is public record, and it takes 5 minutes to find. If your name is on that deed individually, and there is no trust or TOD designation protecting the transfer, you are one event away from your family spending 14 months and tens of thousands of dollars in a courthouse. Mistake number 2, adding your child's name to the deed to be safe. This one comes from the right place. You want the house to go to your kids. You want it to be simple. You have heard that joint ownership avoids probate, so you walk into a title company or download a form online, add your child's name to the deed, and feel like you handled it. You did not handle it. You created 4 new problems that did not exist before you signed. The first problem is a tax bill your child does not see coming until they try to sell. When a child inherits a home at death, the IRS resets the property's tax basis to the fair market value on the date of death. This is called a stepped-up basis. If you bought your home for $80,000 40 years ago, and it is worth $350,000 when you die, your child's basis becomes $350,000. If they sell it the following week for $350,000, they owe $0 in capital gains tax. $0. The entire $270,000 in appreciation disappears from the tax calculation entirely. When you add your child to the deed while you are alive, that stepped-up basis disappears for their share. They receive what is called a carryover basis, your original purchase price, for the portion you gifted them. If they sell that home after you are gone, they owe capital gains tax on $270,000 of appreciation that inherited property would have escaped entirely. On a $270,000 gain at the long-term capital gains rate, that is roughly $40,000 to $54,000 in taxes owed on a home they otherwise would have received tax-free. You did not save your child anything by putting their name on the deed. You handed them a tax bill they could have avoided if you had done nothing. The second problem is that your home just became exposed to everything going wrong in your child's life. The moment your child's name is on the deed, they are a legal co-owner. Their creditors can place liens on the property. If they are sued, your home is part of the legal proceedings. If they file for bankruptcy, their interest in your home becomes part of the bankruptcy estate. If they go through a divorce, their share of your home can become a marital asset subject to division. None of those events require you to do anything wrong. They require your child to have a bad year. And you can no longer protect the home from any of it because you already transferred partial ownership. The third problem is that you just lost control of your own house. Once your child is on the deed, they are a co-owner with legal rights. You cannot sell the home without their signature. You cannot refinance without their approval. You cannot take out a reverse mortgage without their cooperation. If they disagree with your decision to sell and downsize, you are legally stuck until the dispute is resolved. If they die before you, their share of your home may transfer to their spouse or their children by operation of law, leaving you co-owning your own house with a son-in-law or grandchildren you did not choose as co-owners. The fourth problem is that in most states, adding your child to the deed is treated as a taxable gift of half the property's value. For 2026, the annual gift exclusion is $19,000. On a $400,000 home, gifting a $200,000 interest means filing a gift tax return and reducing your lifetime exemption by $181,000, even if no tax is owed today. The tool that accomplishes what you are trying to do, without any of these consequences, is a ladybird deed in states where it is available, or a transfer on death deed, or a properly funded revocable trust. All three allow your child to receive the home after your death with the full stepped-up basis, no exposure during your lifetime, no loss of your control, and no probate. If your child's name is currently on your deed and this is news to you, talk to an estate planning attorney this week about correcting it before more time passes. Mistake number 3, the trust that was never actually funded. This is the mistake the California father in the opening of this video made, and it is the most common, expensive mistake in all of estate planning, because it looks exactly like the right answer until someone opens the drawer and checks the deed. A revocable living trust is the gold standard of probate avoidance. It works. It is private. It transfers your home instantly and without court involvement when you die. Estate planning attorneys recommend it thousands of times a day. It is not the document that fails. The process around creating it fails. Here is what happens. You hire an attorney. You pay $1,500 to $3,000. You sit in an office. You sign documents. You go home with a binder. You tell your family the house is protected. You feel finished. What you did not do, and what your attorney may not have explicitly walked you through completing, is record a new deed transferring the property from you as an individual to you as trustee of your trust. That recording is a separate legal action. It requires a new deed. It has to be filed with your county recorder's office. Without it, the trust does not own the home. You own the home. And when you die, the home goes exactly where it would have gone if you had never created the trust at all, straight to probate court. Estate planning attorneys in California describe this constantly. Clients come in convinced their home is in the trust. They have the binder. They have the document. When the attorney checks the public record, the deed has the client's personal name on it, unchanged from the day they bought the house. The trust was created and never funded. There is another version of this that traps people who did fund the trust correctly at first. You refinanced your home 5 years ago. When you signed the new loan documents, the lender required the deed to be in your personal name for the transaction. The refinance completed. Nobody retransferred the deed back into the trust. The home is now out of the trust and in your personal name again, and you have no idea because you have not looked at the deed since. This happens constantly. Every refinance, every home equity line of credit, every transaction that requires the lender to hold the deed temporarily creates the risk that the property never gets retransferred back into the trust. The action you need to take this week is simple. Go to your county recorder's website or office and pull the current deed on your property. Read the name on it. If it says your full legal name as an individual, not your name as trustee of your trust is decorative. It is legally real but practically worthless for the purpose you created it. If the deed is wrong, call your estate planning attorney and request a trust transfer deed. The correction is straightforward. The cost is modest. The consequence of not correcting it is your family spending 14 months in a process you paid to avoid. Mistake number 4. The transfer on death deed with no backup. This one is the most avoidable of the 4 and the one that blindsides families the hardest because everything looks like it was done correctly until the exact moment it is not. A transfer on death deed is a powerful, low-cost tool. You record it. You name your beneficiary. When you die, the home transfers to them directly. No probate, no court, no delay. In states where it is available, it is one of the cleanest solutions to the problem of keeping a home out of probate. Here is the trap. If your named beneficiary dies before you do, and you have not updated the deed, the transfer on death designation fails entirely. The property does not pass to your beneficiary's children. It does not pass to your other children. It falls back into your estate and goes through probate as if the deed never existed. A woman in Illinois recorded a TOD deed naming her son as beneficiary. Her son died 3 years before she did. She never updated the deed. When she passed, her family assumed the house would transfer automatically to her grandchildren. It did not. Because the son predeceased her and there was no contingent beneficiary named on the deed, the property went to probate. What was supposed to be a clean, immediate transfer turned into a 9-month court process. The fix is naming a contingent beneficiary on the deed at the time you record it. A contingent beneficiary is a backup, the person or entity who receives the property if your primary beneficiary cannot. Most TOD deed forms have a line for this. Most people leave it blank. There is also a second version of this mistake that is less obvious. Some states require a TOD deed to be re-recorded if you want to change or revoke it. Telling your family your intentions changed is not legally sufficient. The deed in the public record is the controlling document. If you have had a falling out with a named beneficiary, moved, remarried, or simply changed your mind about who should receive the property, the only thing that matters is whether you filed an updated deed with the county recorder. Check your TOD deed today if you have one. Verify the named beneficiary is still alive. Verify they are still the person you intend to receive the property. Verify there is a contingent beneficiary named in case something happens before you do. And verify the deed has been re-recorded if your intentions have changed since it was first filed. Here is your complete checklist. 1. Pull your current deed from the county recorder's website or office. Look at the name on it. If your personal name appears without a trust designation or transfer on death designation, your home is headed to probate. Call an estate planning attorney this week about a trust, a TOD deed if your state allows it, or a ladybird deed in Florida. 2. If your child's name is already on the deed, talk to an estate planning attorney about the capital gains tax implications and your options for correcting the title. The stepped-up basis your child loses by being on the deed while you are alive can cost them tens of thousands of dollars more than any probate fee would have. 3. If you have a trust, verify the deed shows the trust as the owner, not you personally. If you have refinanced since creating the trust, specifically confirm the property was retransferred back into the trust after the loan closed. 4. If you have a transfer on death deed, confirm there is a contingent beneficiary named. Confirm the primary beneficiary is still living and still your intended recipient. If anything has changed, file an updated deed. All 4 of these actions can be started with one phone call to an estate planning attorney or one visit to your county recorder's website. The cost of the call is 0. The cost of ignoring this is measured in months and percentages of everything you built. This is Daniel Kim. If this video helped you, hit the like button right now. 1 second, and it helps this reach more retirees who need to see it before it is too late to fix. Subscribe and turn on notifications. Drop a comment and tell me which of these 4 situations describes your deed right now. I read every single one. The most common situations become the next video. I will see you in the next one.